Welcome back to #Lawyered, and you knew we weren't going to let Halloween come around without us doing a special episode talking about the do's and don'ts when it comes to this holiday. So sit back, listen to our stories, and we're going to try and tell you a little bit about what you need to be worried about or not worried about this Halloween. Welcome back to #Lawyered, you guys, and this is our second episode coming out this week. We got the election episode followed up by, of course, our Halloween episode.
Guys, I love a good theme. Not to be basic, but I do.
Well, and I mean, this was easy. Like, this was an easy choice. We're obviously going to do a Halloween episode. We're obviously going to talk about some stupid stories and have some fun with it. Now, a couple things just to lay out kind of what we're going to do in this episode.
Yes.
We're going to present we're going to present some scenarios of some typical Halloween type parties or events, things like that, and discuss whether or not there could be liability for these hypothetical situations.
Could.
So, a couple things, we're not giving legal advice. We're just
Very
talking.
important. We are not, guys, we are not. Please do not take this as legal advice. This is not creating a client-attorney relationship here. These are just our thoughts on hypothetical situations.
Yeah. Well, and I'll tell you, too, you can trust that I'm never giving legal advice unless you've paid me. So, don't worry about that.
Likewise. We like to be paid first.
And we're also, this is something I think that people can get caught up in, and it's important to understand. When we talk about these scenarios, and really when we talk about any kind of hypothetical fake story, we're not really talking about would you win, would you lose, could somebody sue you, because on the win-lose part, there's way too many factors that go into who wins, who loses.
Oh, my gosh.
And a lot of times nobody wins, nobody loses. It's a split the thing in half or whatever.
Yeah, split the baby. I hate that analogy.
That's why I didn't say it.
It's appropriate. It's gruesome, so it's appropriate for Halloween.
It's a good point. And everybody says it, so I get it. The other part is that anybody can sue anybody for anything. So whether or not you could get sued, that's not a real question, to be honest.
Yeah,
there's not a real answer to that question.
Yeah, because you absolutely can be sued.
Yeah.
It's just, will you have any form of success on that suit? Now that's different entirely.
Yeah, I mean, really what we're going to focus on is our personal opinions on the situations. And the cool thing is we're just going to talk about all the different sides of it. Could be this way, and really just try to give some in-depth analysis on this is the factors that play into all of this.
Yes, absolutely.
And so before we get into the stories themselves, two specific areas of the law I think that it's important for our listeners to understand.
Yes.
Because they apply to this and they apply to a bunch of others, and we're going to have some other stories that go into this. But what is negligence and what is premises liability?
Right.
And those are terms that get thrown around a lot. Negligence gets thrown around a whole lot.
Oh my gosh, guys, negligence, it's actually, seriously, it's a defined term in the law.
It is. And it gets thrown around by lawyers and non-lawyers.
Yes,
so
this is true.
We're guilty of it too.
Yeah.
The paraphrase definition of what we're really looking at is that people owe an ordinary duty of care to other people. And there are certain times where, because of a position that you're in or a relationship you have with a person, you have a heightened duty to provide certain types of care or make certain decisions for them. And the way that I phrased it in here, and Andrea, please elaborate on this if you got an easier way to think about it. But, if I'm aware of a danger, and as an ordinary person, I would warn somebody of this danger, or I would do something about it, or I would take action, and I don't, and this actually hurts somebody, at that point you could be negligent.
I mean, it's arguable. But we'll see. We're already going into could you not?
Right.
But as a very general paraphrase situation, I just honestly I feel like these are just easier with examples, right?
They are. I mean, one of the ones I wrote down, you've got a dangerous dog in your yard, and it gets out and bites somebody. You know that if the dog's bitten somebody before, that's something you probably know about and should have either warned or taken some action to keep it from happening.
Like keep the dog inside.
Correct. Or have a sign up that says beware of dog.
Yes.
Things like that.
Absolutely.
That's part of it. We talk about car wreck cases. That's a negligence thing. You have a duty to not break the traffic laws.
Yeah.
If you are speeding, following too close, whatever, you hit somebody.
Yeah. You have a duty to drive reasonably.
Right.
Like you shouldn't be, on Instagram, selfieing live, recording while you're driving, and then smack into a minivan.
Right.
That's
right.
You're not being reasonable.
Yeah.
A reasonable person exercising ordinary care wouldn't be, oh my gosh, so today I am wearing a Charlotte Tilbury, and then smack, while you're recording.
Yeah.
And
Right.
That's not cool.
And so the second part, which is probably more applicable for the stories we're going to talk about today is what's called a premises liability
Yes.
case. And again, I'm going to keep this very high level because you can get as detailed as you want to with all these types of situations. But the easiest way to think about it is you own a piece of property or building. There's a condition on the property that poses some type of a risk of harm
Sure.
to people who are walking around on the property. And you either knew about it or you should have known about it because it was
Yes.
obvious. And then you as the owner failed to warn others or to make the conditions safe for these other people. They get hurt with it. There's different categories of this, and I'll briefly go into it, but
Sure.
there's these different categories called an invitee, a licensee, and a trespasser. And we're talking about the person who got hurt.
Right.
Licensee is someone that is on the property for something that's going to only benefit them. This is kind of a weird concept.
Yeah, it's very weird
And it doesn't
outside
apply
the
very
law.
often. Yeah, it doesn't apply very often. I mean, the examples that I looked up that are best talked about are, say a person's cutting across a parking lot and cuts their leg on a sharp piece of metal. They're not on that parking
Yeah.
lot, your parking lot, because they parked there and you guys both are benefiting from that. They're just cutting across.
It's a strange situation.
Parking lot owner could be held liable for that,
Yeah,
potentially.
maybe.
Trespasser, that's pretty obvious. They're not supposed to be there. They break
Yeah.
in, they hurt themselves, and we won't get into that. The invitee, which is a legal classification, is the most common one. Because the legal definition is the person who gets hurt is on your property for the mutual benefit of one another, i.e., someone goes into your store to buy clothes. They're trying to buy clothes, which is their benefit. They're spending money, which is your benefit.
Yeah.
They're an invitee. You have a duty to make sure there's not an unreasonably unsafe condition there
Yeah.
at your store.
And I mean, this applies like all over too.
Right.
I mean, it applies like when you're traveling. Like if you are fancy pants and you're taking a private plane to Napa. Well, maybe that's a bad example because of the fires. Sorry, guys. I'm so
Well,
sorry.
if you're on an airplane anyways.
Yeah, if you're on an airplane, right? So you're in the terminal, right? You've paid to get into the terminal.
Right.
Only people who have tickets can get into the terminal. And if there was a giant gaping hole in the middle of the terminal that no one put any signs up, and then you trip and break your ankle, okay, well, the owner of the terminal can now be in trouble.
Right. And I think I've got a case example of a case I tried a year ago. So a bar fight case. That's a great example.
Ooh, true life story.
True
Love
life
this.
story. You can have some mixture of negligence and premises liability. Usually in these types of situations, premises liability is more the appropriate
Sure.
area of the law. But in this case, we represented the bar. There was a drunk patron that was a little rowdy, and then there was the patron that eventually got hurt. Well, funny thing is actually a heavy metal bar. So
What?
a heavy metal bar. So
Okay.
if you're familiar with mosh pitting, we actually spent a good deal of jury selection talking about mosh pitting, whether it's acceptable, whether if you knew that this bar had mosh pitting available and that people moshed, whether you'd be impartial as to whether or not this was a premise that they created an unsafe condition.
Okay.
And I'm a heavy metal fan, so this was a lot
You
of fun.
are?
Oh yeah.
Guys, I didn't know this.
You didn't hear
What?
the music out of my truck when you pulled up this morning?
No, I was cranking my own music, and it was not heavy metal.
So with this situation, it was a very sad deal. The plaintiff ended up getting hit in the head with a bar stool from this drunk patron and had some severe damage, major surgeries, plate in the head, all kinds of stuff.
Terrible.
The surgeries were fine. The guy he's okay now as far as the procedures all went well, but
Yeah.
obviously he was extremely injured. Terrible situation because this asshole did what he did.
Yeah, a lot of pain.
And so this guy disappears, as people that do.
Shocker.
So the injured person sues the bar, and so we have a lawsuit on our hands. And the idea was that the claim was that the bar should have recognized this drunk patron, recognized that he was causing havoc, causing a problem, and this created an unreasonably unsafe condition. The bar should have done something to remedy that, and they didn't, and that's what caused the injury to the plaintiff. And so that was the case. Now, that legally they were allowed to bring that claim, and they were allowed to have the trial on it. Jury eventually ruled in the bar's favor because the man that was hurt kind of engaged, and they didn't actually swing fists, but he kept engaging with the man who eventually hurt him. Jury found that was somewhat of his own fault, and that the bar really did everything they could to try and remedy the situation, because the entirety of the whole thing happened in 26 seconds. So
26 seconds
between the first contact between the injured person and the culprit, we'll call him.
Wow.
Which I will tell you, just kind of as an aside, that sounds short. When you're in a jury trial and you're watching 26-second stop, start, slow motion, back up, it seems like it's been 40 minutes that this whole thing happened. Because so anyways, that's an example of a premises liability situation where, and the jury found what it found, but legally that's what you're dealing with here. We got an unsafe condition. Do I have a duty to fix that? Did I do my job? And that's kind of what we're dealing with here. So, and that's going to apply to quite a few of these scenarios that we're going to talk about here. So, I'm going to lay out this first one, and then Andrea, just you tell me what you see as potential problems here.
Also, I love the name you picked.
Oh, thank you.
It's so
appropriate. I tried to get creative with these. So Chad decides he's going to make a haunted house in his rent house. And he equips the place with smoke machines. He's got friends dressed in zombie outfits who are going to jump out of closets and scare people. He's got some booby traps that could force some of the people that are walking through to kind of trip and fall. And he's going to bring all these people in to come and see this. So, what should Chad be worried about? And I think first off, let's just talk about some of the potential problems that you see just right off the hand that he should be concerned. We're not going to tell Chad to call it off. It's his own choice, but
you do what you want, Chad.
Tell him what he should be concerned about.
You should be concerned about a lot, Chad. It's a problem. Okay, first of all, make sure there are no minors coming in because I'm assuming there's also alcohol on the premises.
Oh, well, I don't know that. So okay. That's a good point. If there's alcohol, could have some issues there.
Yeah, just not with the minors.
Good point.
That gets nasty.
Yeah, well, and we'll get into some of that in the second one.
Okay, so first of all, the smoke machines. Okay, that's problematic because now you have a condition where you're limiting visibility. And so, for example, if you have, because some people have sunken living rooms, right? And so,
oh yeah, good point.
Yeah, right. And so that was like a really big thing in the 70s, I think, to have a sunken living room. And so if
it's probably a good spot for the booby trap.
Right. It probably is. So if you're walking into the house and the smoke machines are going and you don't know there's a sunken living room and there's like 3 or 4 steps that you have to go down to get to the living room. Okay, well, you can't see. You're walking and all of a sudden, boom.
Coffee table. Right to the forehead.
Right to the forehead. Or, God forbid, the temple or the back of the head.
Yeah.
I watched Outer Banks last night, and that's how a character, kind of, sort of almost died.
Oh, geez.
Yeah.
Okay. So like Final Destination stuff.
Yeah.
A little bit.
Okay. I don't know that movie.
Oh, wow. Well, it's a...
I don't do horrors.
Okay. Well... Listeners probably know it, but basically it's a movie where these people keep they see their death or they see how they're almost going to die, and then they see that the logs fall off the back of this truck and slam through their windshield, and then all of a sudden they snap out of it and they're driving behind a truck with logs on it. So oh,
that's terrible.
Yeah. So anyways,
I couldn't handle
back
that.
to this.
But anyway, so that's a problem, right? Because Chad knew that he had a sunken living room, and he knew the smoke might obscure that. He didn't warn anyone about it. He's like, oh no, it'll be fun. It's a party.
Yeah.
Okay, and then they fall and get hurt. That's a problem.
And a lot of this stuff boils down to, as the person Chad who's putting the smoke machine in. Well, obviously it's clear that you're obstructing people's vision with the smoke. So it's reasonable to assume that somebody could not see something like a sunken living room and fall through it. And so if you do something like that, and it's reasonable to conclude that could happen, it's far more likely that you can be held liable for that because it's not like 6 different 6 degrees.
It's foreseeable.
Right, it's foreseeable.
Very foreseeable.
You can it's reasonable to see that it could happen.
Yes.
It's not like 6 different things had to happen for this outcome to occur.
Yeah, and it's not like something intervened and made it happen. Right. We won't get too much into that because that goes into another issue.
A little bit on the intervening. Let's talk about the surprise zombies.
Oh yes, that's a great intervening situation.
So you've got I'll just throw the hypothetical out. Let's say that Chad's friend Sam. We'll go with Sam.
No, I want to go with Brad.
Oh, Brad, that's better.
Yes.
Chad's friend Brad is hanging out in one of the closets, and he jumps out, scares somebody, and hurts them somehow. Doesn't matter how. They injure themselves. And so then, we've got Chad who's renting the house and just throwing the party, and who hired asked Brad to come and be the zombie. Then you got Brad who potentially caused an injury. What are we looking at there?
So now you're looking at a big problem, right? Not just for Chad, right, who is the one renting the property, but also possibly for the rent house owner, right? Because it's technically the property of the rent house owner. And he could potentially be held liable if this Brad jumped out, scares the person, and they jump back, smack their head, or jump back and trip and break an ankle or something because this person was now injured on the rent house owner's property of which Chad was a tenant of.
Right.
And so Chad he was the one who brought the zombie Brad on, and was the one who asked Zombie Brad to be this scary, potentially accident-causing figure.
Nice.
And so, yeah, he knew that it was possible someone could get hurt.
So I'm picturing Zombie Brad with these like really short khaki shorts, a pastel-colored polo,
Little chubs.
little hat flipped up forward.
Frosted tips.
Right, there you go. So we're talking about intervening cause a little bit too, because there's kind of two things that came to mind when you were talking about that. So one, Chad could say, and again, we're just saying what couldn't happen, that kind of deal. Chad could say, well, look, I didn't tell Brad to jump out and smack him in the head with a baseball bat. Like I didn't tell him to do that.
Okay, that's excessive. Let's go with like a foam noodle covered in fake blood or something.
Okay, that's better. Thank you. That makes a little more of a closer call. Okay. I didn't tell him to use a foam noodle covered in blood. So like
fake blood.
I didn't tell him to fake blood. I didn't tell him to do that. So that's something that's outside of my control. I shouldn't have been able to see that. And then landowner who actually owns the house, because like we said, Chad's renting. Landowner could say, well, I didn't know what was going on here. This is out of my control.
And in fact, maybe the landowner says in his contract that you can't have gatherings of more than 5 people.
Right.
And Chad invited 20, and then Brad, because he's Mr. Popular, has invited like 500.
Right.
Okay, that's way more than 5 people.
They got to see a zombie costume.
Yeah, exactly. They have to see his zombie costume.
Well, and that's the reason we kind of circled around it. Here's the reason landlords put things like that in their contract, because then they can say, well, look, I shouldn't be held liable for what they did. They broke the rules. That's an intervening cause.
It is an intervening cause, and I couldn't foresee that happening. It was superseding, intervening, not foreseeable. I took all the steps I could as a landlord to make sure that didn't happen.
Yeah.
And it happened anyway. How could I have known it was going to happen? I did everything right.
Now, here's a little twist on things. Does it matter whether Chad invited the people that hurt themselves? Does it matter whether he invited them over, or whether maybe he just opened his door and you've got some people who are just neighborhood kids walking by, or neighborhood adults, we'll say, walking by that come in and explore? Does that really make a difference?
No, not at all.
Because they're still there. They're still in the premises, on the property, and still potentially getting hurt.
Yeah.
Now, here's something. This has far-reaching implications to a bunch of other things other than just haunted houses. But obviously, we have these big, professionally done haunted houses. And what's one of the biggest things you sign before you're allowed to go in?
You sign a liability waiver.
What do you think about those? How effective are they?
No, not effective very much.
Not at all. And everybody thinks they're effective, and that's probably the reason they are effective, is because, to me, in my opinion, the only thing I've seen them useful for is what I call a deterrent, because it makes people think, well, maybe I can't sue them.
Yeah, and it's completely ridiculous. I mean, a lot of these are what we call adhesion contracts, which is just a fancy way of saying they're kind of useless and pointless. You have to sign them to be able to play.
Right.
And if you don't, you can't play. So, of course, you're going to sign it because you want to play. And so it does not offer the level of protection that the person who wants you to sign the contract thinks that it offers.
Right. And, the analogy I always think of is a roller coaster.
Yeah.
Say that on the back of your Six Flags ticket it says that you assume all risk and the waive Six Flags liability of anything. Well, look, if someone flies out of that coaster and is severely injured or, God forbid, dies, Six Flags can't just flash the ticket in front of the the court and say, look,
do that.
We're not responsible, because that's not how that works.
No, especially if Six Flags was, negligent, right? Here's that word again.
Yep.
In maintaining the roller coaster. They failed to exercise, a reasonable duty that any other theme park that does what they does has to check the harnesses and the roller coasters to make sure that all the safety features work.
Yeah. And that's one of the biggest myths that I, like to debug is liability waivers don't mean much.
Yeah, they're, nope.
So let's go to our second scenario, my favorite one of the three. Fraternity Halloween party.
Does this bring back your college days?
A little bit. So Trevor and the Delta Tau Chi fraternity throw a Halloween rager at Favorite College. And anybody who gets that reference, props to you, DM me. It'd make me very happy if you got that movie reference. So they got kegs, they've got trash can punch with dry ice for effect, and they've invited as many scantily clad nurses as they can, who may be mental after they have some of the trash can punch.
Ooh.
So, first off, before we get into some more spin-offs of that, what are some of your concerns at the right out the gate with this party?
Minors and alcohol.
Okay, that's one.
Okay, yeah, that's a big one.
Especially at a college, because you got, mixed bag
right.
here.
Two, right? So you don't know what's going into the punch. So if someone is like deathly allergic to a dye, that's possibly a problem. If you've got red dye 40 zillion in there and you have,
It's a good
Nurse
red dye.
Ratchet.
I've had that before.
Oh, I'm sure it's real tasty. Yeah. Are you glowing afterward?
Yeah, absolutely. It's part of the Halloween theme. It's part of the costume.
Yeah, and then you have Nurse Ratchet Jackie, walking
Ooh,
in.
I like that one. Yeah.
I can play with these analogies. Walking in and she's horrendously allergic to red dye 4 zillion or whatever. Drinks a bunch of the trash can punch and then goes into anaphylactic shock. Okay, well.
There's a word.
Yeah. So the fraternity can be in big trouble for that.
Yeah. Well, and so let's kind of go off on a little tangent here.
Yeah.
So let's talk about Nurse Ratchet Jackie.
Mm-hmm.
So there's this thing that we talk about that it's got a kind of a cool name in law called the eggshell doctrine.
Yes.
And I think we've mentioned it on the show before.
I think we have briefly mentioned it
but
before.
You explain it better than I do. Kind of let our listeners know what the eggshell doctrine means in terms of the stuff we're talking about.
Sure. So eggshell, I often have heard it referred to as eggshell plaintiff, right? So if a plaintiff is injured, right, maybe a normal person is only going to be injured to X degree, but this person is injured to XYZ million degrees. So generally this is kind of explained better, I think, through a hypothetical, but you take the plaintiff as you find them. So for example, if you have Susie Q driving and then she is hit by John Doe, if Susie Q is a normal, healthy 29-year-old woman, okay, she might have like a little bit of a sore back, but she's fine. But they're driving, and now you have, Jackie driving in the car. But Jackie, Reese is recovering from a broken back because she's a stunt woman in a Hollywood film, and she's in a back brace. And then she's slammed into, okay, well, maybe with a normal person like Susie Q, sore back is all. But with Jackie, because she's recovering from a broken back, her entire back is jacked back up again.
Yeah.
And then she has to go in for surgery. Okay, well, you are liable for all of that. The person who crashed into her is liable for all of that because he has to take the plaintiff as he found her.
Right.
She was in a delicate, fragile condition, right? Just like an eggshell is delicate and fragile, so was the plaintiff's back in this situation. So just because a normal person would only be hurt a little bit, that doesn't mean anything. You have to take the plaintiff as you find them.
Right. And so, let's just go back to the punch. Let's say that somebody put something in the punch that actually they messed up. Let's just call it food poisoning.
Sure.
And it would have given a normal person food poisoning. And so, that's kind of where the bar is.
Yeah.
But then Ratchet Nurse Jackie, she actually has an allergic reaction because she's allergic and she got food poisoning. Well, just because you didn't know that she had a condition that would react to it, you still are potentially liable for all the damage she suffered, regardless of the fact that she's different from other people.
And that can get very expensive.
Oh, yeah, absolutely. Absolutely. So let's talk about something that I think a lot of people get confused with when it comes to people leaving parties like this.
Yes.
And because this happens all the time. It's very sad. And I deal with this on a fraternity basis a lot because of the work I do with some of our fraternities here.
You want to pimp that out for a second?
Yeah,
that's actually really exciting.
so I'm on the board of directors for Alpha Tau Omega, one of the big fraternities here in the U.S. across college campuses, and a lot of what we do is try to get in front of trends such as dealing with sexual assault, dealing with binge drinking, and all the types of things that go into that. And of course, we also deal with the lawsuits that happen in scenarios like we're talking about here. And typically, what happens is you've got a guest or a member of the fraternity that gets intoxicated, leaves the party, gets into a wreck and hurts or unfortunately kills a third party who was not at the party, who was driving, all those kinds of things.
And this person was intoxicated when they left.
Yes. Right. And so, this can happen with a bar, this can happen with a routine social gathering at a friend's house, it can happen at a college fraternity party. And you get a couple of things, playing in here. So, and I'm going to read from some of these, the statutes. So in Texas, you can be liable for a scenario like this or for serving alcohol at a social gathering. So let's take it out of the bar scene for a second. House party, fraternity party, we even call it. If a host knowingly serves alcohol to minors, they can be liable. Pretty point blank, duh. Get
Obviously.
Get that. Second, if at the time that an alcoholic beverage was provided, it's apparent to the provider that the person being served this beverage was obviously intoxicated to the extent that he or she presented a clear danger to themselves or others. And then that person who was drunk causes damage to somebody else.
So let's make this a colorful example, right? So we have Brad in his disgusting, fantastic zombie Brad costume.
He left the haunted house and he went to the Delta party.
And he's at the Delta party, and he is now the bartender, and he is serving, ratchet eyeball drinks. And they are loaded with Everclear. And he gives, Jeanette
Nice.
Right?
Yeah.
I'm on a roll with these names today. He gives Nurse Jeanette 10 of these ratchet eyeball drinks filled with Everclear.
Right. She's cute. He winks at her. He wants to, make he wants to look cool. So yeah,
he's like, I want your number.
Yeah.
Okay. And so finally, Nurse Jeanette's friends are like, okay, we're bored. We're leaving. Bye.
Yeah.
And he gives her another drink. Well, girl is stumbling.
Mm-hmm.
She can't talk straight.
Right.
She literally has to be held up by one of her friends, and he gives her a drink anyway.
Yep.
Ding, ding, ding.
Yep.
Big red no.
Right.
Very bad move, Brad.
Right.
Very bad move.
Right. And let's say that Jeanette, unfortunately, gets behind the wheel of a car and hits a family, and let's just say no one dies. Let's just say that people are injured. And then that family, at that point, I mean, they've got some legal options to go after Brad.
Yeah.
For serving. Mm-hmm. They can go after Jeanette.
Can they go after the fraternity?
They will go after the fraternity. They definitely will go after the fraternity. And I won't get into all the nuances of all the legal background of how there is or isn't liability there, but they're going to sue the fraternity.
Yeah.
Because the fraternity's got the deeper pockets out of everybody.
Cha-ching.
And what they're going to say is that was a fraternity party. Mm-hmm. The fraternity provided the alcohol to Brad, who then provided it to Jeanette, who then, under the Texas Alcohol Beverage Code, Section 2.02, she went out and hurt somebody. Mm-hmm. Now, it's important to understand that this isn't just a civil liability. Under the TABC law, you actually can be found guilty of a Class A misdemeanor for doing this.
Oh, I actually didn't know that.
Up to a $4,000 fine, up to 2 years in county jail. So it's actually a criminal offense in Texas. And so that's part of the deal. Now, one term that gets thrown around a lot I want to demystify a little bit is people always say, oh, yeah, Dram Shop Act. That's kind of dead in Texas now. It's not really applicable. It's more of this TABC law that really controls is because the dram shop there's been a bunch of restrictions on it and a bunch of things that you still find it in a lawsuit. I mean, I've got one going right now where we've claimed Dram Shop Act.
And so for the audience, Dram Shop Act is specifically referring to like a bar, right? Some sort of actual commercial establishment that is providing alcohol to patrons, and then the patron leaves the commercial establishment, gets in the car, hits the family. So on and so forth.
Yeah.
And they sue the bar, yes.
And so that still exists. It's not dead, but it's been significantly limited, and this TABC regulation is far more applicable in those situations, and then just general negligence situations as well. So on a serious note, if you are throwing parties, Halloween or otherwise, really be careful about your guests. And with Uber and everything, do the right thing. Help your friends out when they're trying to get home. But, and understand that you can be held liable, even if you're just having a party at your house and someone goes and gets hurt. Not only, guilty conscience part, but legally, criminally, you can be held liable because of this act and because it's, you're serving alcohol to someone who clearly doesn't need it any longer. If you do that, fine. Get them an Uber. Get them home.
Get them an Uber, get them home. And just, guys, it's okay to be that friend and be like, look, you can't even stand up straight.
Right.
Your keys are going in my sock drawer, and you can come back and get them tomorrow morning when you're sober.
Yeah.
It's not happening. And also, guys, one last thing. With the flashing lights, seizures, people, actually, I didn't really realize this. Seizures are much more common than I thought.
Oh, yeah?
So I just kind of recently was learning about this. So if you're going to have, flashing strobe lights, I really would urge you just to at least show, if you ever wind up being in court because you have the strobe lights that triggered someone's seizure, to at least show that you were trying. Just post some sort of warning.
Yeah.
Just show that you're trying, that saying, hey, there are strobe lights in here. If you're sensitive to flashing lights, maybe don't come in.
Right.
So just...
Yeah.
So, try.
Just try.
Just try, guys.
Make an effort. So let's talk about last scenario here that is a little bit more germane to a traditional Halloween.
Yes.
We've got handing out candy to kids.
Tradition. So what I did last year.
Right. And I don't want to get into the fact that it may not be as prevalent this year because of everything. But let's say in normal times, 5-year-old Sarah is allergic to Starburst. Specifically. She's allergic to that, nothing really else.
Not Warheads, not Tutti Frutti, just Starburst.
Just Starburst.
Oh, I love chocolate.
But her parents don't know this. So they take Sarah around, they're trick-or-treating, they're having a great time. She's dressed in a princess outfit, just having a phenomenal time. There you go. Perfect.
Favorite Disney princess.
There you go. So she grabs 2 handfuls of candy from the house on Sycamore Street and doesn't realize there's a couple yellow and orange Starbursts in the mix. Not that she would know anyways, but there's a couple of them in there.
So maybe this should be Elm Street.
Yeah, maybe. That's a good point. And then she eats them and she gets sick.
Yeah.
And so parents are mad, they're upset.
Like really sick. Like
Really sick.
she's vomiting
Yeah.
so much that she's like so dehydrated she has to go to the hospital for fluids.
Exorcist vomiting, that kind of deal.
Ugh.
Halloween theme. I know you haven't seen the movie.
No.
So
Can't do horror.
let's talk about this. So facts are, she doesn't know, parents don't know she's allergic. She gets sick from, she has an allergic reaction to the starburst. Homeowner's responsible for that? What's the scenario there?
So this one's a lot murkier, and I think honestly it can go either way. I would say that eggshell plaintiff probably applies here.
Yeah.
And so, I mean, you have a little girl. You take the plaintiff as you find her. She's horribly allergic to starburst. No one knew, which it kind of strange to me that no one knew, but okay, that's fine.
Right.
You still have to deal with that fact.
Yeah.
So I think at some level you would be responsible. Now, there's always the question of, could you be responsible? Yes. Now, is the jury going to find you responsible?
Yeah.
Okay, here I think it depends where you're at, right? But I think a jury probably would have some sympathy and a little bit of annoyance, I think, for the parents. You know, if your child is deathly allergic to starburst, don't you think you should know that as a parent?
Yeah. Yeah, well, and I think so. Flip side, I think you got a foreseeability issue potentially too.
Yes, that's a very good point.
Did the homeowners, could it be reasonable for them to assume or think that if I put out certain candy, someone could get sick because they're allergic?
And they don't know.
And they don't know. And they don't. Yeah, that's a good point. That's kind of the X factor
That's
here.
the big
Is
twist.
it reasonable that for me to assume that parents don't know their child is allergic to something and wouldn't take the proper precautions to make sure their
they're
child
not going to
doesn't
supervise
ingest?
their candy,
Right,
Because,
right.
I mean, I have friends who are parents of small children, and if the kid is allergic to peanuts, they've told their child like, hey, you can go trick or treating. I'm going with you.
Yeah, no paydays.
But yeah, no paydays. And before you eat any of the candies, we got to sit down and sort it out. And then she
Right.
takes away anything that has a peanut or might be processed in a peanut facility.
Yeah.
And then you just have the safe stuff, and then the kid can go to town.
Right. And that touches on like the next kind of changing of the facts. Let's say Sarah's parents do know.
Yeah.
And then it still happens. At that point, you get a little bit more of a break for the homeowner, I would think.
I think so. And I think, frankly, the jury, because a lot of times, right, you have the facts, like legally who could be responsible, but it's just going to boil down to the jury, right?
Yeah.
Is the jury going to swallow that, oh no, the homeowner, even though no one really knows about starburst allergies, should have known that there was a remote possibility that this one little girl out of the 30 kids that come trick-or-treating there every year might be allergic to starburst.
Yeah.
And that her parents won't do anything about it.
Yeah, and that's a key component of what would the jury decide, and we get asked that. Well, what would the jury say here? Well, we don't know what the jury would say. 'Cause
It's different every time.
12 peers. I do like the fact that you said, would a jury swallow that fact? That was good. That was good.
That was unintentional too.
Okay, then let's add one other fact to this. What if
Okay.
the parents, as they walk up to the door, tell every homeowner, "Hey, my daughter's allergic to starburst. Don't just let's make sure we don't get her any starburst." And then starbursts end up in there. Parents don't check, and then Sarah ingests them and gets sick.
So I think this can go one of two ways.
Okay.
I think one, if the homeowner said, oh, okay, hold on, and then doesn't hand Sarah the basket of goodies, but instead grabs a peppermint New York patty and hands it to Sarah, that's fine.
Yeah.
But if he or she says, oh, okay, and then just hands the bowl, knowing that there's like 70% starburst
Right.
in that bowl, then I think the jury might say, okay, you're an adult. You couldn't just reach in and grab her a piece of chocolate.
Right.
You gave a 5-year-old child the ability to just grab and go.
Right.
So I think maybe the jury would say, less of a break.
Yeah. Yeah.
But again, I think there's also an onus on the parents, at least in the jury's mind, to be like, guys, this is your child. Like, have a little responsibility.
Well, and this discussion illustrates what we talked about at the beginning. There's not a you will win, you won't win, you will be liable, won't be liable, because one, all facts point to potentially different outcomes, and two, if you end up in front of a jury, everything goes out the window, and it's kind of who tells the best story.
It is, and I'm really glad you brought that up. It's advocacy, right? Because in these fact situations, they're really muddled, and when you have a really muddled fact situation, that is a great opportunity for advocacy from your lawyer.
Right.
So, you want a lawyer who can tell a good story and be liked by the jury.
Absolutely.
So it's really important.
Well, guys, hopefully this discussion, lined out some things that you can think about as you go through Halloween, and also really apply to greater life. So, learn from Chad, Brad, and Ratchet Nurse Jackie.
And Sarah's parents.
And Jeanette, and the Delta
Jeanette.
Tau Chi fraternity at Faber College. and look that up if you don't know what that reference is. Thank you guys for being here. Really enjoy your Halloween. Think about these things. You got any questions or have any other scenarios? We started to get some DMs from people asking questions. Keep them coming.
So excited. We love that.
Yeah.
We love hearing from you guys.
Keep giving us topics that you want to hear about.
Yes.
We want to keep talking about those things. We're going to now close out, but stay tuned for our closing argument about Melania Trump. We've got some controversy with the Department of Justice, and y'all have a happy Halloween.
Happy Halloween, y'all. Hey, y'all. Thank you so much for listening to #Lawyer today. But wait, before you go, we want to make sure that you know where to find us on all the socials. So catch up with us on the audiovisual portion on YouTube. We have a #Lawyer channel there that we're very excited for you to take a look at if you want to put some faces to names. I know I love doing that. Make sure to follow us on our Instagrams, whether it be the #Lawyered Instagram or Austin's and my personal Instagrams. We check all three, so make sure to DM us or frankly leave comments on all of our latest posts to make sure that we're covering the topics that you guys are interested in. And if you have any questions or you're like, hey, I heard this in the news today, I think it's really interesting. I kind of want you and Austin to break it down for me and give the legal perspective so that I am well equipped at my next dinner party or Zoom cocktail hour, COVID and all that, to be able to discuss this with my friends. So again, thank you so much for listening. Make sure to rate and review the podcast on whatever platform that you're listening to. And we are so thankful that you're listening, and tune back in next week. Bye, y'all.
Today on Closing Arguments, we've got, of course, an appropriate story during election season. The U.S. government, through the Department of Justice, filed a civil claim against former Melania Trump advisor Stephanie Winston Wolkoff for publishing a book, Melania and Me, The Rise and Fall of My Friendship with the First Lady. In the allegations, they state that Winston Wolkoff, like all other White House employees and volunteers, had to sign a non-disclosure that prohibited her from speaking about any of her time at the White House, whether through audio, book, publications, anything at all. They sued, claiming she violated the non-disclosure, and in my opinion, these claims are insane. They're claiming that Winston Wolkoff breached the NDA that's probably not enforceable, that she owed a fiduciary duty to Melania Trump and the United States not to disclose what she sees and witnesses while she's volunteering at the White House. Keep watching to see how long before this case gets tossed, or if this was purely some political stunt right before the election.